Mr. Cook.
Yes, good morning. So I'm going to open my cross appeal.
Yes, thank you.
Now, and as you know, this is an appeal about the judge's valuation of GBRK as at the 18th of October 2011.
Yes.
And you'll have seen that the judge had the benefit of written and oral evidence from two qualified valuation experts. Firstly, my expert, Mr. Hayward Crouch of BDO. He considered that it was inappropriate to value GBRK as a going concern as at that date. And so he applied a net asset valuation to GBRK.
Yeah.
And what he did was he made adjustments to a balance sheet dated the 31st of December 2011 to arrive at a net assets valuation of £280,000. And then secondly, Mr. Hall of Smith & Williamson, who after revising his opinion also applied a net asset valuation to GBRK and similarly considered it inappropriate to value it on the basis of a going concern. And he made fewer adjustments to the balance sheets of the same date and concluded his valuation at £400,000. Now, if the judge had arrived at any valuation for GBRK between £280,000 and £400,000, the respondents wouldn't be appealing today. But as we know, notwithstanding the expert evidence, the judge instead found that GBRK was worth £800,000 as at that date, i.e. twice that of the higher of the two expert estimates before him. And as we've touched on already, the judge did so on the basis of an investment made by a friend of Mr. Monk's, Mr. Miles Simmons, who gave £200,000 and was in return given 25% of the shares in GBRK. And the judge prorated that investment up, multiplying it by 4, to achieve a valuation of £800,000. Now, as I've already touched on, neither expert considered that to be the most appropriate methodology for valuing GBRK. And we say that the judge's finding was irrational and can't stand.
Yeah, now, can I just ask whether that last sentence, or rather the penultimate sentence, is correctly phrased? Neither expert thought it was appropriate, rather than neither expert thought it was correct.
Well,
because there is a difference.
Well, the experts were asked to give their professional valuation of GBRK.
Yes, but you understand what I'm saying. Did either expert say this is wrong?
Well, I think the most I can say is that they said neither of them adopted it. Neither of them used that methodology.
Yeah, you might have to taste to the transcript, because there is some narrative, isn't there, behind this?
Yes. Well, I will be taking you to that in due course. Yes.
And in a similar vein, I've rather understood it to be the case that both experts agreed it was ultimately a matter for the judge to decide on the appropriateness or not of.
I think we have to be careful about what they were talking about.
Okay.
I'll come to that.
Okay, as long as we're coming to that, it's fine.
Absolutely,
yes,
absolutely. Now, while I accept ultimately that a judge is not bound to follow the opinion of an expert, a judge should be very slow in my submission to deviate from the unanimous opinion of two experts, and the judge must provide a cogent explanation if they choose to do so. And we say that the judge's factual finding was plainly wrong for two reasons. Firstly, the judge failed to explain why he rejected the valuation opinion of Mr. Hall, as he was required to do. And secondly, in any event, there could be no good reason to prorate Mr. Simmons' investment as a valuation for GBRK, as opposed to adopting the methodology taken by the two experts. And we also said the judge's methodology and conclusions, basing it on Mr. Simmons, were inconsistent with many of the other findings he made, including that GBRK was insolvent, both on a balance sheet and cash flow basis, and that Mr. Simmons believed GBRK to be insolvent.
And you'll take us to that part of his judgment as well?
I will. And so my submissions this morning will broadly follow the structure of my skeleton argument. First, what I intend to do is briefly review the treatment of expert evidence by the first instance court by reference to the two decisions, basically, of this court, Smith and Co-op and Griffiths and Toohey. Secondly, I'll comment on what findings the judge did and didn't make in the judgment. And thirdly, and in particular, I'll look at how the judge treated the opinion of Mr. Hall, and I do so because we do say that the judge failed to adequately explain why he rejected the methodology adopted by Mr. Hall. And finally, I'll explain why there could be no good reason to adopt a new methodology, given the judge's other findings and the other evidence before him.
Yes, you keep referring to Mr. Hall. Didn't both experts adopt the same methodology, but just come to a different result?
They adopt, yes, that's correct. So they both valued GBRK on a net asset basis, and to put it simply, the difference between them was this: they both started with a balance sheet of the year-end date, and my expert took out more assets than Mr. Hall did, and so he arrived at a lower valuation than Mr. Hall. But both of them were adopting it on the net asset basis.
Yes, so it was the same methodology.
It was the same methodology. Yes. In a sense, I don't dwell on my own expert because I'm not, as it were, seeking to invite the court to take that valuation.
It's just that you kept referring to Mr. Hall.
Yes, indeed, and that's the expert that, in my submission, the judge needed to distinguish from, because I'm not seeking to disturb the judge's conclusion that had he had to decide between the two of them, he would have gone for Mr. Hall's and not Mr. Hayward Crouch's. I
mean, it's often said that it's an art, not a science, the valuation of companies.
Indeed, but it is something that is a body of recognised expertise, and that's my point. When
it can result in very, very many different conclusions. But there we go.
Indeed, and we had them in this trial. They were, as one moved on through the dates, the experts diverged very, very significantly as to their conclusions. So
the problem is, of course, we do have the evidence of a very real transaction in the real world, which was the investment by Mr. Simmons for $800,000 on what the judge found to be a commercial basis.
Yes, I'll certainly come on to address that.
State the obvious. That's really the big difficulty in your path, I think.
I'll explain why I say that it isn't a proper basis to value the company, but we'll come on to that.
And Mr. Cook, I know you're going to counter it, but as I understood it, the experts looked at this injection of £200,000 and the effect that that would have. Your experts said it wasn't arm's length. Mr. Hall said it was arm's length, but they both accepted that wasn't an issue for them. It was for the judge to decide whether it was arm's length. I'm just summarising what I think it was the situation before we go any further. But they both, and Mr. Hall said it was a reality check for his $400,000, but that was as far as they took it on board.
Yes, it's a point I rely on, which is that as far as Mr. Hall used it in any sense, he was only using it to bolster his chosen valuation as opposed to that of Mr. Hayward Crouch's. So it was in that context that he used it. We'll come on to look at how he dealt with it. But the matter for the court aspect I'll also deal with in some detail, because in a sense all they can have been saying was that the evaluation of Mr. Simmons' own motivations for making the transaction was a matter that they obviously couldn't opine on, because they were dealing with the numbers and that sort of thing. But they had his statement and they'd read it, and we'll see that from the joint memorandum.
Can you just remind me of this also before we go on to the structure of your arguments? And I'm sorry to take you off course so early on, but can you remind me, did either of the experts attempt to evaluate that which did feature in consideration of the computation of equitable compensation, which is the allowance to be made for the very real asset of the company, GBRK, which was Mr. Monk? We've talked about real assets. What about that asset? Did either of them attempt that? Because Mr. Simmons did, of course. That's what he told the judge, that if it wasn't for Mr. Monk, he wouldn't be putting any money in there.
Well, indeed. It is my lady's question that, in a sense, one has to look at the value of Mr. Monk as an individual.
Well, it's quite common for people to say that the value of a company isn't necessarily reflected by its real assets, but the drive and commitment of a managing director can make all the difference. And we've got evidence before us of a company which, as the liability judge found, doesn't really build up a customer base. It's as good as its last skip. And in the last skip being delivered, it's usually got an imprimatur of the person behind the business. But there we go. Did either of them take Mr. Monk's contribution into account? Because that was the evidence before the court, and perhaps you can come to that in due course as well.
I think we will. I mean, I'm going to show you a document that might explain what the experts were sort of trying to achieve in terms of the accounting definition of market value. And it may be in that context that this sort of thing comes in.
All right.
But
I'll try and keep
I mean,
quiet.
if I haven't answered the question by the end of my submission, then please do it again.
I'll try and keep quiet for a while now.
Yes. So the structure is basically I'll go through the law relatively briefly, 2 cases, and then we'll go into this case.
Okay.
So the first case I was going to take you to was well. Let me just explain what I intend to show you by these cases. I'm going to start with the question of the role of the first instance judge and the appellate court on this appeal. And effectively, I'm dividing it in my submissions in the law into 3 areas. Firstly, I'll examine how a judge should approach fact-finding when they have the benefit of expert evidence, looking at the decision of the case of Smith and Co-op. Secondly, I'm going to explore how a judge should approach an issue where 2 experts substantially agree by reference to the decision in Griffiths and Toohey. And thirdly, I'll touch on what the role of the appellate court is when dealing with an appeal like this.
Yeah, and just, I did say I'd be quiet. They are quite well-known principles, so...
Yes, I'll do so as quickly as I can.
All right.
So let's turn straight away then to Smith and Co-op. It's in Authorities Bundle 2.
Thank you.
It's tab 34. Page 1199 it starts.
Thank you.
Now, we don't need to read all of the facts. I mean, the situation was this. The first instance judge was considering a road traffic accident, and the claimant was a child who cycled out of a driveway into the path of a lorry that was driven by the second defendant on behalf of the first defendant, Co-op. And the driver failed to sound his horn. And one of the issues at trial was whether, even if the driver had sounded his horn, the child would have been able to escape the path of the lorry. And the first instance judge heard expert evidence to the effect that even if the driver had sounded his horn, the accident was already inevitable by that point. And what happened was that the judge rejected that evidence, preferring to rely on his own experience of driving. And one sees that if one goes to page 1203, internal page 345. It's a paragraph 37, and this is it's in the judgment of Lord Justice Morbick, but he's quoting the judgment of the first instance court.
Yeah.
And one sees it's paragraph 37 of that quotation. And then after a few lines, I pick things up a few sentences down, beginning with the sentence, "The suggestion has been made."
Yeah.
And he says this: "The suggestion has been made largely in evidence that came from Dr. Searle, that was the expert I just referred to, that sounding the horn would have done no good. I do not accept that. Dr. Searle suggests that research shows that reaction times of 2 seconds for the person hearing the horn. This is apparently based on some research using volunteers and machines. My own experience, so far as driving is concerned, is that one reacts pretty instantaneously to the shock of a horn going off, and a slow-moving cycle would have been able to stop quickly or make a sharp turn to the left to avoid where the sound was coming from. If the second defendant had sounded his horn, as he could have done, at a time when the defendant was halfway across the pavement, there would have been, albeit only seconds, sufficient time for the claimant to stop and move to his left, away from the approaching vehicle and perhaps away from the squeal of brakes. I'm satisfied the claimant could have done that, and he would have done that." So this was a situation where the judge was preferring his own driving experience to that given by the expert. And moving ahead to how that was treated by this court, over on paragraph We can pick it up on page 12, 1205. And going to what Lord Justice Moore-Bick said, at the end of paragraph 14, we can pick it up there. The judge, however, rejected that evidence, preferring to rely on his own evidence, his own experience of reacting to the sound of a horn while driving. In my view, the judge was wrong to reject Dr. Searle's evidence. He was not bound to accept it, of course, if he had good grounds for doing so. But if he was going to reject it, he should have given reasons for doing so, other than simply saying that it did not accord with his own experience. It is tempting for judges, when dealing with matters of everyday experience, to regard their own perceptions and experience as more reliable than the opinions of those who seek to describe such matters in scientific terms. The temptation should be resisted, if only because the layman's perception of matters of this kind may well be wide of the mark. The layman may think that he reacts to something instantaneously. The scientist may be able to demonstrate that he does not. And then he concludes by saying there were no satisfactory grounds for rejecting the expert evidence, and that was the way in which the case was decided. So the simple point arising from that is this: if a judge can't bring their own perceptions and experience on everyday matters to a case, this is all the more so in respect of technical matters like company valuation, which is a recognised body of expertise. And in my submission, a judge should resist the temptation to consider that they know more about the area than an expert does. Now, my second point follows from the comment of Lord Justice Moore-Bick in Co-op, which is that, of course, a judge isn't bound to accept expert evidence, and I obviously accept that. However, a judge does, in my submission, need some sound basis for doing so, and paying due deference to the expertise of the expert witness. And that leads me on to dealing with the leading case in the area, which is Griffiths and Toohey. If we could just, bundle 2 can be put away now. And if I can invite the court to take up bundle 4, authorities bundle 4. It's a tab 60, the first tab in that bundle. And so just to set the scene, this was a recent case where the leading judgment was given by my Lady Justice Asplin. So I beg her indulgence while I summarise the facts and the judgment for the benefit of the other members of the court. It was a breach of contract claim where the claimant was claiming against the holiday provider in respect of an illness which had allegedly been caused by contaminated food or drink provided at the hotel. The claimant adduced expert evidence of a medical consultant, and the defendant didn't adduce any competing expert evidence at all. Nor did the defendant cross-examine the expert witness. It then criticised the expert report in its closing submissions, alleging that the report failed to discharge the claimant's burden of proof. And the first instance judge found the report to be non-CPR compliant, and it had a lack of reasoning in places, and refused to place any weight on it on the issue of causation. In other words, whether the illness came from the health and safety failures of the resort. And it's helpful to look at the way in which that report was described by the first instance judge. If the court could turn to page 2178. One sees there, we don't need to read it all, but Professor Pennington's report is the heading, and one sees in the first sentence, the judge described it as minimalist, and then what my lady did was to quote virtually the whole of the substance of the report in this paragraph. So one sees at paragraph 13, you've got paragraphs 2 to 4, which, as I understand it, comprised essentially the whole of the report. So that's all quoted there. And it had only 3 substantive paragraphs. And then moving ahead to paragraph 16 to 17 of the judgment, over at page 2180. I just invite the court briefly to glance at those. It's paragraph 16, and then over the page. It's clear that there are a number of criticisms made by the first instance judge of the report, and one sees at 17 and 18 finding that it wasn't compliant, and decided that Mr. Griffiths had not proved his case and therefore dismissed the claim. And she made a point about the burden of proof, saying it was open to the defendant to sit back and do nothing and save make submissions, and if the evidence is not sufficient to satisfy the court on the balance of probabilities, the claim will fail. Pause here, but by way of contrast, to say that in this case, no criticism was made of the reports of either expert in this sort of regard. And propose to skip over the summary of the judgment on appeal and the submissions of counsel to the discussion of the law by my lady at paragraph 40. It's on page 2187. And to set this in context, what the judge who'd overturned the first instance judgment had concluded was that effectively the judge had no option but to accept the evidence that was proffered by the expert. And my lady said this: I should say to the outset that in my judgment the authorities do not support the bright line approach adopted by the judge. There is no rule in an expert's report which is uncontroverted and which complies with Part 35 cannot be impugned in submissions and ultimately rejected. It all depends on the circumstances of the case and the nature of the report itself and the purpose for which it is being used in the claim. I should also add that none of the authorities on which, to which we were referred were dealing with experts' reports which were inadequate in some way. And then moving on to paragraph 50, which is on page 2190. Having summarised some of the authorities, including the decision of Lord Justice Clark and Coopers and Payham, my lady summarised in this way. In principle, I do not dissent from Lord Justice Clark's conclusions. If the report of a joint expert covers the relevant issues and the conclusion is supported by logical reasoning, and it is the only evidence on the topic, it is difficult to envisage a situation in which it would be appropriate to decide that it is wrong. That does not mean that such circumstances may not exist. After all, both sides would have instructed the expert. As Lord Justice Clark points out, it all depends on the circumstances. And then moving forward to page 2192. My lady then sets out a further summary by reference to the comments of Lord Justice Hickenbottom in the case of Whitting first Keolis, And what's said is this: while Lord Justice Stuart Smith said in Liddell and Middleton, we do not have a trial by expert in this country, we have a trial by judge, where experts are agreed on a matter within their technical expertise. The judge will only rarely reject that evidence and should not do so without applying considerable caution and giving out adequate reasons. And my lady then goes on to address the issue as to whether or not the expert needs to be cross-examined by the party seeking to impugn the conclusion in the report. And I note parenthetically here that while there was cross-examination of the experts about their proposed methodologies, Mr. Davies did not ask Mr. Hall why he declined to value GBRK by reference to Mr. Simmons' acquisition. I think I just asked the court to note, but we won't read what my lady says at 65 and paragraph 65 and 66 on page 2194. And then over the page at 2195, at paragraph 69 and 70, that's about the issue of cross-examination. And in summary, my lady concluded that where there's going to be a criticism that the report didn't comply with the relevant parts, part 35, and seeks to criticise whether or not the claimant has satisfied its burden of proof, it isn't necessary for the party to cross-examine the expert on that. They don't need to be given an opportunity to make good the deficiencies in their evidence by reference to cross-examination. And Lord Justice Nugee gave another reasoned judgment in this. And I just wanted to take you to one passage of his Lordship's judgment at paragraph 83, which is on page 2197. His Lordship says this: on the issue of guidance from the Supreme Court in Kennedy and Cordia, it is clear an unsubstantiated assertion by an expert is worthless, because what carries weight is the reasoning and not the conclusion. And then his Lordship sets out a quotation from the Routstone case when he says, what really matters in most cases is the reasons for giving the opinion. As a practical matter, a well-constructed expert's report containing opinion evidence sets out the opinion and the reasons for it. If the reasons stand up, the opinion does. If not, not. So he's making the obvious point that the court's in a position to analyse and evaluate the reasons that have been given by the expert. And I should just note very briefly, Lord Justice Bean gave a dissenting judgment. That was confined, he otherwise agreed with the rest of the court, but it was confined to the issue of whether you needed to cross-examine the expert on if you were entitled to subsequently impugn or challenge the conclusion they seemed to reach. His Lordship's view was that you did need to cross-examine.
Yeah. Obviously, I'm not quarrelling with these statements of principle, which are in a way binding on us, but I must say, speaking for myself, it doesn't seem self-evident. An unsubstantiated assertion by an expert is worthless. And one reason you go to an expert is because of their built-up experience and expertise in the field. And one would hope one should normally be able to assume that if they express a view on something, they will have a reason for doing so.
Yes,
even if it's not, and as my lady says, it's not a science anyway, to a degree. So in that kind of a situation, anyway, yeah, we have to have reasons.
Yes,
on the authorities.
But it's because of the reasons that often it derives its force. I think the court's making a point about the weight of something is obviously much more
quite say it goes to weight, but yes, we're told it's worthless, which means you can absolutely disregard it totally.
Well, I mean, I wouldn't say that either, but no. Yeah. So to sort of summarising the analysis, one sees that there are important differences between factual and expert witnesses. Obviously, an expert's role is to deliver their opinion and not to report a simple fact. And the reasonableness of their opinion, and so the weight that a judge can place on it, is susceptible to analysis. And very little weight can be placed on the pure assertion of an expert. Going to my Lord's point, it may not be worthless, but it may be difficult to place a great deal of weight on an unreasoned conclusion of an expert. Conversely, a judge will need a cogent reason to consider that his opinion is more reliable than an expert in the field. Of course, it's not impossible, but in my submission, a high bar exists, and a judge should be cautious before doing so. An obvious example, though, would be a manifest error by an expert. Clearly, if there's been an arithmetical error, or it's obvious that there's been a typo or something like that, then clearly the court is perfectly capable of rejecting it insofar as it needs to, in the case of an obvious error.
Well, there's many reasons why a judge may reject an expert's opinion. There could have been, as it were, the necessity to find facts before an opinion can be provided. And if the expert proceeds on a certain assumption, and that assumption is undermined by the findings of fact or supplemented by findings of fact, then obviously the judge can say, well, that's all very good and well, but you've kind of stopped short of where I've gone to.
Yes, I infer
that's
from
in
what
the
my
authorities that you've referred to. I'm not speaking specifically about this. I'm just saying that we've got to be very careful that the authorities are not bright line, you have to accept or not. What it does obviously indicate is everything depends upon an assessment of all of the evidence, not just the expert evidence, but the expert evidence seen in the context of the whole.
Yes, we'll come on to discuss how it works in this case. I'm not suggesting that they're
and of
right
course
line.
you're just pointing us to the principles at the moment.
Indeed. I sort of draw a distinction then between obviously expert evidence, which I've just discussed, and that can be contrasted with the approach to factual evidence. Obviously, a witness of fact is overwhelmingly going to be a matter of assertion. For example, I saw this on this day, or this was my impression of the event. The strength of factual evidence, therefore, depends much more on the credibility or the court's assessment of the credibility of the witness in question. And the judge can obviously safely question that credibility where, for example, there's a contrary contemporaneous document or something along those lines, or the judge makes an assessment of the witness's demeanour to accept or reject their evidence. So there's a sort of difference in approach in terms of how the first instance court is entitled to accept or reject factual versus expert evidence. And the third topic I'd like to touch on in relation to the law is the role of the appellate court in evaluating a first instance judge finding of fact and where the judge chooses to deviate from the opinion of experts. Now, my learned friend, I think, relies on the Volpe case, which I believe is in the tab just behind Griffiths and Toohey. I don't dispute, for the avoidance of doubt, that the role of an appellate court is to decide whether the decision is one which no reasonable judge could have reached. I think my learned friend intends to rely on paragraph 2 of that judgment, which summarises the test. He'll obviously make his own submissions in due course, but I don't dispute that it's the correct test. But as I said, there are important differences between findings of fact based on expert evidence and those based on factual evidence. And in my submission, this court should be more willing to review a finding based on or, in this case, rejecting, in my submission, expert evidence for 2 reasons. Firstly, because the opinion of an expert is susceptible to analysis. They will inevitably have set out their reasons and conclusions in a written report. And the appeal court can see both the expert's reasoning and also the judge's reasoning in accepting or rejecting it. And those are matters that are capable of scrutiny by this court. It can ask itself the question, was the reason given by the judge good enough? By contrast, of course, it's much more difficult for this court to scrutinise a decision about a witness's credibility. For example, the judge saying, I believe this witness over that, or I don't rely on their evidence, because although even I would say for demeanour, this court takes a much more, or courts in general take a much more cautious approach to matters such as that. One has in mind the decision of Mr. Justice Leggett, as he then was in the Guestman case, about caution about treating people's demeanour as determinative of their credibility.
And so, Mr. Kick, you're accepting, I think, that the question of whether the transaction was at arm's length was for the judge, and that he made that decision as a question of fact and decided that it was. That isn't your concern. Your concern is that he used a different methodology. So it's that narrow issue, a different methodology from that which had been used by the experts.
Yes, I do say that. I think just before we move on about the arm's length distinction, what the judge actually found was that Mr. Simmons's investment was a commercial one. That was the finding that he made. There's a section in the transcript where I think the judge seems to think that the arm's length is a matter of accounting definition. I think he says something along those lines. We'll come to it, but it's important to bear in mind what the judge actually concluded. He concluded that Mr. Simmons' investment was a commercial one.
Yes.
I think that was the phrase used. So, and the second reason why it's easier for this court to review expert evidence is because that evidence is usually primarily in writing. They'll set out an often lengthy written report. So, just before I move on to discuss the present...
But we've still got to determine whether or not the judge was reasonable. Not that we'd have come to a different conclusion.
No.
But whether or not the judge reached a decision that was outside the realm of reasonable decisions open to someone as well informed by the expert evidence and the other evidence as he or she.
Yeah.
You
I accept
that?
that's the test for
Right.
evaluation of... Yeah. So before moving on to discuss the present case, I'll just draw some threads together. The starting point of an analysis is that the judge should not presume to know more about any fact or opinion than the witnesses before them. In that context, a judge should be very slow to deviate from expert opinion, especially where the experts agree or in this case agree within a range. But by definition, an expert knows much more about a specialised matter than the judge. Secondly, a judge may consider that the expert's report is insufficiently reasoned or incomplete, and that may provide a good reason for deviating from it. And this was the reason which the first instance judge had in Griffiths. But nevertheless, it remains difficult to see how a judge can deviate from the opinions of an expert if the report covers all of the issues on a correct factual basis. And if a judge chooses to do so, he needs good reasons to explain it.
But sorry about this, but so in this case we've got two experts agreeing or using the same methodology. So there are other cases that I'm sure you've been in, Mr. Cook, and Mr. Shaw's been in, and no doubt the court have been in, where different methodologies have been adopted, and the court then has to determine the methodology that it prefers.
I'm not quite sure I agree with that, my lady. I think the issue as to the most appropriate methodology is itself a matter that lies within the expertise of the experts.
But suppose they disagree.
Yes, well, I mean, you'll have cases like that.
Well, that's what I'm talking about. So there are two experts before the court. One says that I've used this basis to evaluate, and another say no, I've used this basis. So the judge then has to determine between the two of them.
Well, yes, but where there's a conflict, the judge will have to determine, as between the two of them, which methodology.
And how does he do that?
Well, I think it's not quite this case. This case is one where the experts...
No, it's just that you've made an assertion at your second point, and I'm testing it. The judge then has to determine, on the basis of the factual circumstances of the case, which methodology is the most appropriate. And if he or she reaches a conclusion as to the nature of the methodology that he or she prefers, then if it's within the band of reasonableness, it would be very difficult for this court to say, well, actually, we'd have chosen the other methodology.
In that hypothetical example, the judge will be preferring one methodology over another as a result of an analysis of the way in which the experts have come to that conclusion as to deciding on which is the correct methodology. I mean, it's difficult to speak about this in the abstract, but one presumes that you have two experts, one who says, I value this on a net asset basis, the other says on a going concern basis. And the court, and they would have set out one would imagine there are reasons for adopting one methodology over another. And as part of deciding between the two, the court will engage in an analysis of which
So
set of
they bring
reasonings.
their own experience to bear.
Well, my lady, I submit no. What they're doing is they're critically analysing how well the experts...
Yes, it's their judicial experience they bring to bear in determining on the facts of the case which is the most appropriate methodology.
But they're doing so, in my submission, by reference to how the reasons given by the expert for choosing that methodology stack up. I mean, it's quite difficult to talk about in the abstract. I mean, here, of course, I say what happened is that the experts have both agreed the most appropriate methodology is net asset value. And so it's quite different from the example we're talking about. And so in that world, here the judges, I submit, gone out on a limb, essentially, and chosen a different methodology to value the company. So it's very different from the example we're talking about, where within the, as it were, the confines of the two experts, the judge is choosing one over the other.
All right.
But I think I've answered that as best I can.
In the kind of case my lady is putting to you, I mean, there is always, isn't there, in theory, at least a third possibility, because the judge disagrees with both methodologies and adopts one which is somewhere in the middle.
Yes, and
nobody,
provided that they...
that's permissible. It's not. So there's no rule that the judge is not entitled, as it were, to form a conclusion which differs from that put forward by one expert or the other, as long as he explains why he's doing so.
No, absolutely. It's the last part of my lord's...
I appreciate that last part is important.
It's very important.
It's not crucial.
Yes. I've just taken you through, I mean, that's virtually what TUI says. You know, there is no bright line rule, but it's going to depend on what, if any, reasons are given. So I think I'm going to move on now then to the present case, taking it out of the abstract.
Sorry, it's my fault, but I think you were going to go on to number 3, and we've only had 2 so far.
Yes, I'm so sorry. It was really the last point about this court. That reasons are amenable to scrutiny by this court because the whole basis of expert evidence is a matter of reasoning and logic and not the mere assertion of a witness. So I'm just drawing the distinction between the situation where a judge says, I preferred Mr. Smith's evidence to Mr. Jones's. Often it's quite hard to necessarily describe in a judgment exactly why or all of the reasons, but with expert evidence it's different.
Well, there's actually authority to that point.
Yeah.
Saying that it is very difficult to articulate.
Yes. Yes, and I'm explaining why there's a distinction with expert evidence, where often what you've got is you're sort of debating things often on an intellectual sort of level.
Yeah.
So moving to the present case then, it's sort of helpful to start with the evidence of Mr. Hall in his written report, because in my submission it's perfectly clear that Mr. Hall was of the view that Mr. Simmons was an arm's length purchaser, but he rejected valuation by reference to that transaction. And so if I can just invite you to take up volume 3 of the main appeal bundle. And if you go forward to tab 10, page 145. I'm afraid I've dived straight in. This is Mr. Hall's first report, dated the 2nd of March 2021. And if you go to page 145, you can see at the bottom actually is a lengthy report, 123 pages. This is page 106 of 123, page 145 of the bundle. And this summarised Mr. Hall's estimates as to GBRK's FME. And you see a table he set out. And the experts, just to put this in context, were asked to value GBRK over a range of dates. So this was not the only date. And what he did, his first method for valuing GBRK, as at October 2011, was to use a multiplier. And he arrived at the value of 660,000 as at that date. And then he explains how he arrived at that in the subsequent paragraphs. And
sorry, which paragraph are you asking us to look at?
sorry, I'm just asking you to look at the page 145. You see the table.
145. Yeah. Sorry,
Yes.
thank you.
I'm so sorry, my lord.
No, again, my fault.
You can see a number of columns there, and you've got all of the valuation dates that were opined on by the experts. And the column for 2011 is the far left-hand, well, it's the penultimate left-hand column actually. And one sees at the bottom what Mr. Hall did originally was to adopt a multiplier approach to the valuation of GBRK as at that date. And he arrived at 660,000. He then explained why he did that in the subsequent paragraphs. It's not necessary to understand why he did that for the purposes of today.
Sorry, I'm being very dense today. I can't find the 660,000. Is that?
Yes, my lord. If you sort of start at the bottom of page 145,
Yes.
and you sort of work your way upwards, above the words, this working can be explained as follows.
The midpoint is given
Yeah.
as 660. A multiple of 10 gives 793. A multiple of 8 gives 527.
Yes, so Mr. Hall decided that an appropriate multiplier, well, he took two different multipliers. And
So the indicative equity value was 660.
Yes.
Yeah.
That's what Mr. Hall originally concluded as of that date.
I'm so sorry. Which page is the 660 on? I can see the 6603, but I mean that's 6 million.
Page 145.
Right.
This is bundle 3.
Just above 10.5.2, midpoint, first figure.
Sir Launcelot?
It's
Sir Launcelot?
on the left-hand side. Just there.
Oh, thank you. Apologies.
This, I'm sure you've done us a great service by omitting the previous 89 pages and going from page 90 to page 106. But I don't know if it's completely orthodox to do so. If we're being asked to reevaluate something, which you are effectively. In any event,
Well, yeah, I'm not quite asking you to I'm actually relying on what Mr. Hall did.
Yes, but we can't.
Yes.
I mean, we can't see how he's gone about his task in reaching this figure in its entirety. And it's quite clear from the index that there's some explanation. It may be that there are caveats in there that we'd have wanted to consider. So all I'm saying is that I'm very, very, very grateful to you that you haven't asked us to go through 105 pages before we get to page 106. But there comes a time when you have to say, well, this is all very well, but the judge actually had the full report before him, and he also had the cross-examination of Mr. Hall.
Yes.
And examination in chief. But there we go.
Yes, well, what I really wanted to show you in this was the way he treated Mr. Simmons, which is the significant point, and one sees that at page 150.
Right.
And he has a little section about value implied by actual transactions.
This is 10.7.
10.7, yes.
Yeah.
As noted above, he says at 10.7.1, further basis by which to value the shares in the company is by reference to the value implied by any previous transactions in the shares. And if I could just...
So he does recognise then in 10.7.1 that it is an alternative basis upon which to value the company. It is not so unorthodox that it's not recognised within an expert's report.
No, I'm not suggesting it is an unorthodox method. What I'm suggesting is that Mr. Hall didn't consider it to be the most appropriate method for valuing GBRK as at this date. If one goes over the page to page 151, you see Mr. Hall quotes from the evidence of Mr. David Monks, who's Mr. Monks's father, who explains why he invested in the company. And he then, over the page, at page 152, quotes from the evidence of Mr. Simmons. So he had in front of it, or he had in the materials available to him, the evidence, the witness evidence, the written evidence given by these two investors. Mr. Simmons is quoted over the page, at page 152. And then if I could just invite the court to read what Mr. Hall says at the bottom of the page 152 from paragraph 10.7.13 through to 10.7.15. It's just those 3 paragraphs.
So 10.7.15 does say, in my opinion, the fact that he acquired his shares in what appears to have been an arm's length transaction implies the market value of all GBRK's shares at that date was 800,000.
Yes, but he's making an observation about what the consequence would be if you valued it on the basis of that methodology. He doesn't use that methodology to value GBRK as at that date. Ultimately, I'll show you how it develops, but originally he valued it on the basis
Well,
of
you might have difficulty in doing so because I haven't got page 114. So I go from 10.7.15 to 11.1.2.
Yes, that's right, because that was the last paragraph in this section, I believe. I mean, it may be that obviously we can make available the whole report to the court, but I don't think, I think it's
well, we'll see how your submissions go, but
yes.
At the moment that paragraph is not challenging the figure that was chosen by the judge in terms of the actual figure.
Yeah, but what Mr. Hall's saying here is that...
No, we're looking at the report as you ask us to do, which
yes.
is one of the bases that you say that this court has the ability to assess expert evidence far better than factual evidence. So I don't think you can interpret it. That's you giving evidence.
No. I think all I'm pointing to is the fact that Mr. Hall knew about this transaction. He states here that what the value that would be given if you were to prorate it in this way would be this. But Mr. Hall did not, in fact, conclude his valuation at this level. He used a different methodology, and I'm going to show you what happened to his evidence throughout the...
All right.
I mean, the fact remains, this was part of his expert evidence, and it provided a basis which the judge fastened on for 800,000 was the right amount.
Yes.
Which includes the important point as to whether you can do a pro-rating exercise. Plainly, Mr. Hall thought you could, in principle, even though it wasn't his preferred methodology on the facts.
Well, one always can in principle.
Yes.
All he's doing is pointing out what you would do if you did the calculation. But I do submit that there is significance in the fact that Mr. Hall, in his in the sort of ambit of his expertise, concluded that this methodology was not the appropriate one to value GBRK.
But he does implicitly, he does endorse the extrapolation from 200,000 to 800,000, which again is not self-evident when you're dealing with a minority shareholding. I mean,
it's an additional complication.
Well, it is indeed. So he seems to be saying, despite the fact that this was a minority shareholding that was being acquired, one could, going down this route, extrapolate from 200 to 800.
Yeah, but I think all he's saying is that were one to adopt this methodology, that would be the result.
I'm not sure it is all he's saying. He's saying the fact that he acquired his shares in what appears to have been an arm's length transaction implies the market value of all of the shares was 800,000.
Yes.
And there's quite a lot wrapped up in that.
Well,
and he also does say, sorry to interrupt, on the basis that he has set out Mr. Simmons's evidence at 10.7.14, which was, although I paid all this, I don't believe GBRK was actually worth this amount, but I trusted Mr. Monk. Nevertheless, in the light of that, Mr. Hall says what he says at 10.7.15, so he's swallowed that and nevertheless decided that one could multiply 202 by 4 and get 8.
Well, his view was that this was an arm's length transaction. But again, risk of repeating myself, my submission is that given that he was aware of all of that, and as it were, he was postulating different methodologies for valuing the company. He nevertheless...
what was he asked to do?
He was asked...
What were the terms of his instruction? Do we have the letter of instruction? Because you indicated yesterday in your submissions that despite a very specific letter of instruction to both experts, in fact, Mr. Hall did not follow through on the letter of instruction. So, you know, it's one thing to say, despite this, he adopted a certain methodology. In fact, in this particular report, as my Lord and my Lady have said, first of all, 10.715 does make clear that despite what Mr. Simmons says, in my opinion, that's an expert opinion, the fact that he acquired his shares in what appears to have been an arm's length transaction implies the market value is. That's to be read also in relation to the comparison that he makes at 10.7.12, distinguishing between the non-commercial acquisition of shares by Mr. Monk's parents and that by Mr. Simmons, and again to be seen in light of the initial paragraph that you took us to, which is stated to be value implied by actual transactions. So he is providing his expert opinion, upon which, as he indicates on the final page, he is to be cross-examined and also may be likely to be subject to public adverse criticism by the judge if he's not taken reasonable care, and he feels able to make that expert opinion express.
Yes, I think the answer, well, my point here is that, if anything, I mean, the fact that he's gone through all of this and this methodology and set it all out and then doesn't use it, he rejects it, effectively. Mr. Hall rejects that methodology as being the one. I mean, he was asked to answer my lady's question directly. There was an order, a detailed order, that set out what the experts were to determine.
Well, did he receive a letter of instruction?
He did,
Yes.
largely.
And does it copy, as it were, the order
yes,
within it? Have we got the order within the bundle rather than you read it out?
No, we do. It's in volume 2, page 131.
Is this volume 2 of the...
Volume 2 of the appeal bundle.
Of the appeal bundle?
Yes.
Yeah, thank you. Sorry, what was the number again?
It was page 131.
Tab 30.
Yes, sorry, the version I have doesn't have tabs, but yes.
This was at the second CMC, was that?
Yes, exactly. There was vigorous debate about what the experts were going to address in this case, and the result was in paragraph 5. And I don't know if court has this. It's paragraph 5 of the order. It's quite complicated, but it's in particular it's 5(1)(a)(2), which it reads as follows. Effectively, the parties each have permission to produce oral experts evidence from 3 experts as follows: an accountancy expert to address, and then you've got the business asset valuation to address the value of, and then it's a little 2, GBRK's business as at, and then a series of dates. And that's what produced the table that we see in Mr. Hall's report. Just to answer my lady's question, the thing I was complaining about was the fact that Mr. Hall didn't address at all little items, I think 3, but certainly 4 and 5, which were the item, as it were, the identification of individual items between certain periods, and that's why I said we had a lopsided sort of expert report, because my expert addressed everything in the order and Mr. Hall didn't. But what I'm not saying Mr. Hall didn't address the earlier parts of this order, but just to make the point in simpleton, I'm not suggesting that Mr. Hall didn't articulate that this was that within the world of evidence that he had, there was this transaction, and he sort of works through, as it were, if you punch the numbers into the calculator, you get this. I mean, I accept that. What he did, though, ultimately, was what he didn't say was, well, I believe that by reference to this transaction, the value of GBRK at this date was 800,000.
Well, he does in that paragraph.
Well,
if you take a certain methodology, he said, if you take this methodology, I believe that the value of the company as at that date was 800,000, despite what Mr. Simmons says. That's what he actually says in the report.
Yes. Well, no. I that was the basis upon which he was proceeding in the world where he was valuing on that methodology, but he didn't use that methodology.
Yeah, that's different.
As it were, in his final conclusion, and my submission, for the avoidance of doubt, is that the choosing of an appropriate methodology was a matter which was itself within Mr. Hall's expertise. So, to tie it up, it wasn't for the judge to say, well, notwithstanding that Mr. Hall rejected that methodology, I'm going to accept it, or I'm going to run with it as being the
Can you? I
evaluation.
know that you're going to provide us with the full report, but I think you should also provide us with the relevant paragraphs where you say that Mr. Hall specifically says that he would reject the valuation methodology that's suggested at 10.7.1, because you're inviting us, I think, to say that implicitly he rejected it, but if there's any explicit part of the report in which Mr. Hall says it would be wrong for the court to proceed on this basis because of, then obviously we should see that.
Yes. Well, perhaps we'll go through the where he sets out his view in relation to this point. And there's a joint memorandum, and then there's his supplemental reports. And you can see how he uses Mr. Simmons's transaction in terms of justifying the approach he's taken. And in my submission, it's quite clear from that he's not suggesting that transaction is of itself provides the answer to the valuation question. But I'll take you to that. So while we're in, I think you might be in bundle 2.
Yeah.
Go to the joint memorandum, which is at page 138, behind tab 32.
Oh, I'm sorry.
Actually,
Sorry, I haven't. Tab 32 of which bundle?
It's bundle 2, tab 32.
Oh, bundle
page,
2.
Yes.
I've got it as supplementary 1, actually.
Yes, I think it's a supplementary bundle to the appeal bundle. It was included, as it were, as part of the materials for the appeal, and the cross-appeal bundle, as it were, to save space, cross-referred back. So what they did here in this, it's actually a helpful document. It sort of compares and contrasts the views of the expert in one page, and they address various points. And I'm looking in particular here at 138, which is 4.45, Mr. Simmons' investment in October 2011, consideration of arm's length transaction. And one sees here, just picking up what Mr. Hall says, one sees quite clearly that Mr. Hall remains of the view in the left-hand column that while Mr. and Mrs. Monks weren't an arm's length transaction, he thinks Mr. Simmons was. And he debates the issue. I mean, Mr. Hayward Crouch gives all sorts of reasons why he doesn't think Mr. Simmons was ultimately an arm's length transaction. And then, but significantly in my submission, if you go over the page to page 4.46.
I'm sorry, to
But sorry, it's little. It's page 140, and then over the page,
Thank you.
little paragraph 4.46.
Yes.
And this is actually discussing, as it were, the point that my lord raised about the sort of impact of it being a minority stake.
Yes.
So that the experts are sort of considering this.
Yeah.
But in particular, I rely on what Mr. Hall says in this regard. He sort of explains why. So bearing in mind that Mr. Simmons acquired 25% of the then share capital of GBRK, his was a minority interest which would be valued lower than controlling stake, his investment. This implies a higher value for the whole of GBRK than the 800,000 that Mr. Hall has estimated based on Mr. Simmons' investment. Therefore, Mr. Hall's opinion is that, this is the significant bit, the investment by Mr. Simmons shortly before the valuation date of 18th of October provided effective support for Mr. Hall's revised estimate of the value of GBRK of approximately 462,000 as at that date.
That's a jump and a sort of right-hand or left-hand turn, isn't it? One starts looking at the question of minority interest and whether that has an effect on whether 800,000 is the right total when one is using that methodology.
Yes.
And then suddenly one switches to a therefore, which doesn't seem to me to be a therefore at all, in relation to it being support for a different methodology.
In fact, supporting, if anything, a conservative estimate of the value of the company, of which Mr. Hayward Croucher seems to agree.
Well, what Mr. Hall was doing here was there was a debate between them about what the proper net asset value of the company was. Hayward Crouch said...
Yes, I do understand what he was doing, but as my lady says, this isn't implying an inconsistency in Mr. Hall's previous indication in paragraph 10. In fact, he's retaining it. He's merely saying that that's the basis of the conservative estimate of 800,000. But the valuation that's arrived at by this market transaction means that I look at the way that I have reached the figure on the same methodology as Mr. Hayward Crouch, and in fact it supports that, if anything, I'm rather on the low side by saying 462,000. It doesn't. I don't think it helps you, Mr. Cook, this.
I think what I say about it is that he was using the Mr. Simmons aspect expressly to bolster his valuation as opposed to that of Mr. Hayward Crouch's, to suggest that he's saying, well, if anything, the valuation I've chosen in this case, which is the net asset valuation, is conservative, and he's doing it, as it were, by reference to, as my lady points out, a totally different method of valuation. But in my submission, that does support my contention that Mr. Hall had rejected the appropriateness of the net of using a multiplier of Mr. Simmons's evidence, because it
well, how do you get that? I mean, that's not what that's not what it's responding to, with respect. If one takes the issue to have been appropriately summarised in the first column, we get 4.45, the investment in October 2011, consideration of arm's length transaction. And then at 4.46, we get consideration of arm's length transaction, impact of minority share acquisition. Now, Mr. Hall has gone on to say this provides an effective support for my greater figure on the different methodology. It doesn't support by that response, and perhaps this is borne out by Mr. Hayward Crouch failing to make any comment or similar comment. It goes to the valuation of the company on the basis that Mr. Simmons' investment was a minority share acquisition. Now, again, part of your opening sally, Mr. Cook, was this court is in a far better position to assess expert opinion than evidence of fact. if we are being taken to this, we apply it on the basis of what we see in the reports. If it's been changed in cross-examination or examination in chief, no doubt you'll take us to the relevant transcript. But
well, I think the rhetorical question I put is, well, if Mr. Hall considered that this was the appropriate method of valuing the company, he would have adopted it, but he didn't. I suppose maybe that's the highest I can put it. He evidently did, when asked what his opinion was as to the value of the company, what he didn't say was that it was 800,000 using this methodology.
But the fact remains, he doesn't say it was anything wrong with the 800,000 valuation so as far as it went. Indeed, he reinforces his view in the joint report that in the 4.45 that he adheres to that. But then we find him here, really, as my lady has put you, doing something of a sort of U-turn, or at any rate taking a new approach in the middle of this particular paragraph and turning it into a mere backup. But I mean, since it's not entirely clear why he's made that change of approach, and doesn't that make it legitimate for a judge who's dealing with it to, as it were, follow Mr. Hall's first thoughts rather than his second thoughts here?
Well, not in my submission without ascertaining. I mean, it's very hard for the judge to justify departing from Mr. Hall's conclusion as the correct methodology without ascertaining why he didn't take it up.
But aren't we then in a situation where we have two rival methodologies, both of which find some support in the expert evidence, depending on where you look, and the judge exercising his undoubted right in principle to choose between them?
Well, I think my Lord understands.
Not even to adopt an intermediate position, but some figures to say, I prefer this one to that one.
I think my Lord understands. My submission is that because both experts fasten upon a certain methodology, the fact that they might have discussed other methodologies in their reports, it does not provide a legitimate basis for the judge to choose one of those other methodologies that's being discussed, which doesn't form ultimately part of the conclusion of Mr. Hall when it comes to arriving at the figure. That is straying outside of what the experts have done. But I think I don't intend to repeat the point.
No, but Mr. Coop, before you do move off from it's not what they choose to put in their second report. This memorandum would have been prepared as a result of issues raised by the parties. They didn't go off on a frolic of their own, and we see that there is reference to the investment at 4.45 and 4.46, and there may have been reference elsewhere.
Yes.
But it's not what they chose of their own volition to do.
No, you're quite right, my lady. What they actually did was they sort of compared their reports and tried to.
So there was no interaction of the solicitors then. Usually, when there's a joint report, there is an agreement as to what the experts will be asked to give their opinion upon to see if there is any consensus. It's not usually left to the experts of their own free will to go away into a room and say, well, these are the issues we'll ask and answer. This would have had input from the solicitors of both parties. Well,
my recollection, I don't want to say anything that I can't support by reference to what's in the bundle, but I believe the experts discussed the issues that were raised in their original reports.
All right.
And that they came up with that. My lady, I'm not sure I can take it much further, but it's true to say that obviously these are all issues that the experts identified as being ones that they ought to address. And
all right.
Perhaps I can take you to the, as it were, the last piece in the puzzle, which is the Mr. Hall's subsequent report, or supplemental report, which is in Bundle 3, tab 14, page 231. fact, one starts at 230, which is, as it were, a revised table.
And I'm sorry, I'm slightly lost. What's the chronology? This is after.
This is after the joint.
After
yes.
the table we've been looking at.
Yeah. So it's first report, joint memorandum, and then each expert did a follow up.
Yeah.
I think effectively replying to what the other expert had set out in the joint memorandum.
Fine.
And one sees here, obviously, Mr. Hall, he revised his opinion down over time, and what he does here is he uses, as it were, the multiplier approach again to sort of do a evaluation of GBRK as at 2011. He comes out at 296 on his multiple, but what he basically says is, well, that can't be right because it's not as high as the amount that's in the balance sheet as at around that date, and so he effectively rejects using that figure. One says cynically, it was too low, so he wanted to go for the higher figure of the balance sheet. So he effectively adopted Mr. Hayward Crouch's approach, which was to start with the balance sheet. And one sees over the page at 231 what he did. Our revised valuation estimates for GBRK are therefore as follows: 31st of December 2011 as a proxy for 18th of October. So that's the reference to the balance sheet, which had that date. And then the EV EBITDA calculation 296 is his sort of multiplier calculation. And then he says concluded at 400,000 to reflect GBRK's reported net assets as at that date of approximately 439. So he makes a slight reduction to the balance sheet amount to arrive at 400. Mr. Hayward Crouch made more adjustments to the balance sheet to arrive at his 280. But that was the difference between them. But in my submission, again, I say it's quite clear, notwithstanding that he knew all about Mr. Simmons, he did not choose that methodology to value the company.
In his final report, Mr. Cook, to be fair to Mr. Hall, the opening indication in the report is that he's addressing one methodology, because there is a difference between the experts who've used the same methodology, and he comes to the conclusion that as a result of his further investigations, it is correct to reduce his multiple to 7.5, but that's on the basis of that particular methodology. There's no indication in the report that he's asked to consider, as it were, the different methodologies that may be appropriate or may be chosen by the court. And there's no indication that he in any way rejects his first or his previously expressed and consistent opinions that if it was a valuation based upon commercial transaction, it's still 800,000. You agree?
Well, my submission is no.
I know what your submission is, but is there anything in the report that contradicts the statement that I've just made?
Well, I think he's not. Ultimately, the reason why the table shows what it does is because
it's on the basis of the methodology that he's asked to review in terms of the multiple that he uses and the assets that he's valued. He's not asked to review his previous opinion as indicated in 10.1.7 of his first report. There's nothing in that second report that says that that is to be, as it were, overlooked, ignored. Is there?
He's not saying that. I'm afraid I can't.
Well, perhaps the best thing, in fairness to the submissions you've made, is that we bear in mind what the report says, because I think it is that report that we have almost in full.
The first report?
No, the second report.
Yes,
So we'll be able to come to our own opinion on that.
I'm not sure that he expressly discusses here in this report, Mr. Simmons.
He doesn't.
My point remains. I understand my lady's point, which is that he's expressed this how the calculation would work were you to prorate Mr. Simmons. And my point is that notwithstanding that he posits that, that is not the methodology he proposed. But my lady's point is that he hasn't sort of, as it were, expressly said that that's wrong.
No, and he certainly hasn't disowned it, because he still uses it as not only as a cross-check, but also as a reason for upping his final figure to 400.
Well, he does, but I say
that really
well, my
makes the point that it's still very much in play as a potentially relevant way of doing the exercise, and this is more a matter of judgment as to how much weight you attach to it. But
yes,
again, wasn't it open to the judge to take a different view about this matter of weight, given the disagreement between the experts, and come up with his own solution, but one which is firmly founded on the expert evidence of Mr. Hall, albeit in a methodology which he finally doesn't use as his preferred one, but merely as a backup.
Yeah, but I suppose my point is a narrow one, which is that the judge wasn't entitled to reject Mr. Hall clearly in choosing the appropriate methodology, which was a matter within his expertise. That was a significant fact that Mr. Hall had in fact rejected that methodology. Impliedly, he hadn't chosen that as a basis to value GBRK, and that was a matter within his expertise as well. So in my submission, no, it's not quite that the judge has a sort of ability to simply select from a menu. It was significant in my submission that Mr. Hall didn't choose that methodology to value GBRK.
One last question, Mr. Cook. Once the judge had determined that it was an arm's length transaction, Mr. Hayward Crouch appears to not go there because he thought it wasn't. Did anybody ask Mr. Hayward Crouch, when he was giving oral evidence, if the judge determines that this was an arm's length transaction, would you agree that? Did anybody go there?
I don't. My learned friend will correct me. I don't think so. I don't think my learned friend cross-examined Mr. Hayward Crouch on that basis.
No. Okay.
If my learned friend...
Sorry, I certainly did cross-examine Mr. Hayward Crouch on the relevance of Mr. Simmons' investment, and Mr. Hayward Crouch said, and what I put to Mr. Hayward Crouch was, well, according to your methodology, so the net assets value methodology, I said, it must follow, mustn't it, that Mr. Simmons' investment was irrational. And Mr. Hayward Crouch said, oh, well, I wouldn't have made the investment. And then, well, I will show you when I come to my submissions, but I said to Mr. Hayward Crouch, I put it to you that isn't Mr. Simmons' investment objective material upon which you can value the company? And Mr. Hayward Crouch said very fairly, well, it's a matter for the court, but I haven't. So, I mean, Mr. Hayward Crouch accepted that it was a matter for the court. I mean, that's how it was left.
Yeah, that's not quite the question I asked. Once it became, as it were, the time to cross-examine the experts, there's a clear indication in the joint memorandum that one of the experts is refusing to even contemplate a valuation of the company on the basis of Mr. Simmons' investment. Because, just hang on a second, because he wasn't satisfied it was at arm's length. My question was, did anybody ask Mr. Hayward Crouch, if the judge decides that this was a transaction at arm's length, would you agree that the company would be valued at 800,000? minimum?
Well, the direct answer to your question is no, but I will show you the.
I'm sure you will. That's all I wanted to know for the moment, though.
So
Mr.
what I'll be saying is that Mr. Hayward Crouch made it perfectly. He accepted fairly that it was a factual question for the court, and he didn't. And I didn't need to go any further because his position was effectively it's simply for the court to decide.
No, thank you.
It may be helpful to note the reason why this happened as it did is because the first time the submission was made that the valuation should be implied by Mr. Simmons's transaction was in my learned friend's closing submissions. The way in which the cross-examination...
I don't think that's fair, actually, Mr. Cook, because I have seen some of the transcript of cross-examination, and the judge asked questions of Mr. Hall, so it wasn't the first time it was raised. Actually, the judge raised it, as he was entitled to do.
The first time, anyway, my learned friend invited the court to find that.
Well, the judge was entitled to investigate matters with the expert. So it wasn't the first time it was raised, and it was at a time when both you and Mr. Shaw, if you thought it appropriate, could follow up on his questions.
Well, yes. We'll have a look at the transcript.
It was just the question I asked to see where we are on this.
Yes. So let's move on then just to the quantum judgment then. Now, the starting point, as the court knows, is that GBRK is being used as a proxy for the valuation of GBR. And we've seen that material already, and I won't go through all of that. We've already talked about that yesterday. If I could just invite the court to take up volume 1 at tab 16.
Yeah.
I think it must be tab 17, page 302. Now, I'm not going to read all of this out here, but what the judge does at 159 through to 163 is that he summarises the approach of the experts, which we've been to in detail by looking at the reports of the two experts and the conclusions of Mr. Hayward Crouch at 280 and Mr. Hall at 400,000. And once he's over the page 303.
I'm so sorry, excuse me.
He discusses Mr. Hall's valuation, and he mentions my criticism of him in respect of why he'd not taken off more of the balance sheet that Mr. Hayward Crouch had. Because, of course, at that stage, as far as the contest was concerned, it was as between the two, the 400,000 and the 280. And in conclusion, the judge says at 163, thus I would have preferred Mr. Hall's view as to the value of GBRK as at the 18th of October, had I not thought that there was a better and more reliable valuation available on the evidence. So just pausing there, 2 points. One is that it's quite clear that the judge thought that Mr. Hall's view as to valuation was 400,000 and not something else. So he signals a departure from that evidence by saying that he thought that there was something more reliable. And the second thing is, of course, I don't seek to overturn that determination. We're perfectly content for that determination to stand and for the consequence of a successful appeal on this point for it to go down to the judge's backup position, as it were. Now, just to continue to paragraph 164, it seems to me that there is contemporaneous evidence as to what someone considered was the actual value of GBRK as at early to mid-October 2011. This is what Mr. Simmons actually invested for what he was told and considered was a 20%, which was in fact a 25% stake in the company. And then moving over from Mr. and Mrs. Monks over to 167 about his second report. Sorry, this was his first report. He's quoting, we've gone to that. already. And then Mr. Holland then goes on to extract various excerpts from the cross-examination, which is what the court may have been referring to in the course of my earlier submissions. And it's helpful actually probably to turn up the relevant part of the transcript for this, because one sees a little bit more about the context in which those statements were made. If you could keep that open, if possible, and take up volume 3 of the appeal bundle. I'd invite the court to go to page 278 of volume 3. This is behind tab 26. Now, just to set the scene slightly, if one looks at the bottom left-hand box, which is internal page 138, what had happened was I was cross-examining Mr. Hall on the basis that effectively he should have done what Mr. Hayward Crouch did with the balance sheet and taken off items. And I suggested, you see at line 14, well, it's a more accurate valuation, I suggest to you, and the judge interrupted me. He didn't like me using the word accurate, and he said there was no accurate valuation, more appropriate. So he preferred the word appropriate to accurate. And he goes on to say this: there's no evidence of market value here apart from what the experts have said. There is no evidence that anybody offered to buy this company, I don't think, at this time. And I think what the judge is doing there is he's drawing a distinction between a situation where there were later offers to buy the entire shares of the company. I think that's what the judge is referring to there. Therefore, these experts are giving what they think effectively someone would have offered in the market for this company. That is, and then Mr. Hall says, "You're right, my lord, what this is." And then Mr. Hall says this at the top of page 178. Yes, it's entirely theoretical and to establish the market value of the remaining underlying net assets, which I would suggest would be a much bigger exercise than Mr. Hayward Crouch has undertaken. And he says the market value, I would suggest, is better informed by the price at which shares were bought around that time. Now, I think, just pausing there, my learned friend, I think, places great reliance on that statement. But in my submission, that statement comes up in the context of debating different kinds of valuation methodologies. And what Mr. Hall was referring to is, as it were, the principle, or the accounting principle, that in principle, a transaction between that meets all of the criteria for determining market value may well be the best indicator. And I can illustrate that point by reference to a document that both experts had, which is the International Valuation Standards Council's basis of value. And I think if we can just leave that part of the transcript and just go back. In fact, before I go to that, I'll just, before we leave this page, if I could just invite the court to read down the rest of page 139. I continue to press Mr. Hall on why he didn't roll back or attempt to roll back the balance sheet to the position as at October, and effectively Mr. Hall rejects that. And I then put to him at page 140, would you accept therefore that Mr. Hayward Crouch's valuation on a net asset basis is likely to be accurate? And then Mr. Hall effectively disagrees with me, and he does it on the basis that he says that his estimate of the market value of net assets of 280, as Mr. Hayward Crouch, is that it's just after the investments totaling 300,000 were put into the company. So his adjusted net asset valuation of 280 implicitly means that before those investments, the company had no value as a going concern, i.e. no assets, no value based on its earnings, and had negative net assets. Now, I just question whether really that was the case, and if it was the case bluntly, I would say, why did Mr. Month continue trading, and why did those investors put money in? It's just a credibility check. So in my submission, that's Mr. Hall again as it were, using or looking at those investors and using it to bolster his preferred net asset valuation. But I digress slightly. I was going to take you to this.
I'm sorry, I hesitate to interrupt with only friend submissions. Could I invite the court to just to turn over the page and read 141 and 142?
I think perhaps up into the top of 143 as well.
Mr. Cook, where do you want to take us now?
Yeah, so we're going to take you to a document that I think both experts had in mind when they were considering market value. It's page 200 of the same bundle.
And how are you seeking to bring this into the appeal? Was this before the court?
Yes, this was one of the...
And do the experts refer to it and the manner in which they referred to it?
Yes, so this is a document that was discussed. It was mentioned in the joint memorandum. I think they talk about it as IVS 104.
Yeah, and what point are you seeking to draw from it? It's a document that they had available to them. What's the point that you're seeking to make from it?
Well, the point I'm making is that when they're discussing about arriving at market value based on real transactions, what they have in mind is the definition that's in this document, which is that it's produced by the International Valuation Standards Council.
Yeah, I understand that.
Yes.
I'm speaking for myself. The issue that you've put firmly before us is that the judge was wrong to choose as a methodology for valuing the company the commercial transaction pro rata of 200,000 rather than what the experts actually did in terms of them both reaching different figures. So there's no suggestion that one, you've said that your default position is that we go for Mr. Hall at 400,000. So why is it that you want to take us to this? Because you're not challenging Mr. Hall's valuation under the methodology that he and Mr. Hayward Crouch adopted. So why are you taking it as necessary to refer us to it?
Well,
because if those are the correct methodology, or forgive me, if it was the methodology that the judge should have preferred, and he was unreasonable not to, you're not inviting us to say that either of the experts got it wrong, just that they came to different results.
Quite, but no, I'm not, my lady. No, it's more that insofar as the experts didn't adopt the commercial transaction approach to either of their, I mean, they ultimately didn't use that methodology in their reports. The content of this document informs that, because it describes what market value is by reference to the kind of transaction that would inform.
Yes, but that's exactly what they did in that particular expert opinion upon that methodology. So the report that you're taking us to, does that, as it were, completely disown any other method of valuation?
No. What it does is it demonstrates what one is looking for. Where if you're trying to arrive at market value and you're doing so by reference to a commercial transaction, it demonstrates what criteria have to be satisfied in order to reliably do so. And I was going to...
And did you challenge Mr. Hall on that?
Well, the debate between Mr. Hall and I was by reference to...
Yes, so did you challenge Mr. Hall on the basis of this document?
No, I had no reason to, because he was adopting a methodology I was content with.
And so why do you bring it to our attention? That's the point. Did you bring it to the judge's attention?
Well, I think that the judge would have been aware of it. I think he refers to it on paragraph 165 of the quantum judgment.
And did he make any mistake in his reference to it?
Well, he says, perhaps I should take you to what he says. It's page 303 of the of volume 1.
So he's looking at this in terms of the valuation made by Mr. and Mrs. Monk Senior.
Yes, so
not as an arm's length transaction.
Yes, and he says that the experts concluded by reference to this document that that Mr. and Mrs. Monk weren't arm's length.
And nobody suggests otherwise.
No, that was common ground. But what I'm doing is I'm showing you that document to show what the criteria are for, as it were, using or for arriving at market value. What the criteria of a purchaser would be in that scenario.
Did you make submissions on this to the judge below? Well,
I made submissions to the effect that Mr. Simmons was not such a purchaser.
Right.
Was not a purchaser upon who the court could rely. We had the debate about whether effectively he was acting sort of prudently and so on. I'm going to come and make some submissions about that. But I'm entirely your hands up. I was just going to...
I'm only speaking for myself, Mr. Good. I'm just struggling to know exactly what it is that you're saying is relevant to this appeal, in the sense that you made a submission regarding Mr. Simmons and his investment. The judge indicates in 166 that Mr. Simmons was not technically such a party, that is, in a particular or special relationship with GBRK and Mr. Monks.
Yes, I think that's only one of the... This is why I want to take you to the document. It's only one of the subsets.
All right, but I'm just wondering whether or not you're raising new points on appeal that weren't raised in the court below. That's the question I'm putting rather clumsily, I accept.
No. I don't think so. I certainly don't intend to. Look, it may be that the document is... I think I just wanted to show the court what it was that the experts were dealing with. I also think I wanted to contextualise. When both Mr. Hall and Mr. Hayward Crouch say words to the effect of, a transaction, if you like, between a willing buyer and a willing seller can be an indication of market value. What they're referring to is the criteria in this document. That's the point I'm making. Because I think my learned friend will take you to... I think he places some reliance on a passage of cross-examination of Mr. Hayward Crouch, where Mr. Hayward Crouch, I think he characterises it having accepted that proposition.
All right, well, I'm wasting your time, so why don't you take us to the document?
It's page 207 of the third bundle 3. And
it's just the willing buyer and willing seller at an arm's length point, isn't it?
Yes, so paragraph 30.1, page 207, market value is the estimated amount for which an asset or liability should exchange on the valuation date between a willing buyer and a willing seller in an arm's length transaction after proper marketing, where the parties had each acted knowledgeably, prudently and without compulsion. And what this does is it breaks down the components of that rather compressed definition. And I just invite the court to briefly read over the page at 208. It's sub F, paragraph F, G and H.
But going back to Mr. Hall's first report, he's not saying in those paragraphs we've looked at that in any way Mr. Simmons falls foul of any of these requirements in 30.1 or little f 30.2.
No. His conclusion was that Mr. Simmons was at arm's length. Was a purchaser for whom, effectively he did. And then if one goes over the page at page 30.4, page 209, I'll just invite the court to read that.
Nor did he say that there was anything that had to be disregarded.
Mr. Hall.
Mm.
No, I mean this was the framing the debate between Mr. Hall and Mr. Haywood Crouch about whether or not Mr. Simmons was that there could be any weight attached to that particular transaction. But in my submission, just to avoid a mischaracterisation of anything that any of the experts said in the course of their cross-examination about this, in principle, as it were, being a method for determining value, I say it's to be read in conjunction with those documents of which the experts debated, as you saw from the joint memorandum. I want to move on, if I may, just going back, if the court has it, the judgment of the quantum judge. One sees at page 304, Mr. Holland quotes a number of passages from the cross-examination. I think the court will have read this already, but in particular, it's the questioning the following day that Mr. Holland quotes here at the foot of 304. And then he summarises the evidence of Mr. Haywood Crouch as well, and I just pick it up actually and then I interjected, and so the judge said, as he said, it's a matter for me, and this is about the Simmons investment. And in my submission, saying it's a matter for the court, the experts were doing no more than suggesting that it was about the court's evaluation of what Mr. Simmons' motivations were for entering into the transaction. It was clearly a matter for the court and not a matter for the experts. As my Lady Justice Macur pointed out, neither of the experts were asked, as it were, well, if the court concludes that Mr. Simmons was arm's length, then would you agree that the value is 800,000? And then perhaps it's just quicker if the court reads the summary of Mr. Haywood Crouch's cross-examination at 168 and 169. The judge refers back to his extensive quotation of Mr. Simmons's evidence, and what one can conveniently get that from paragraph 142 of his judgment, so back on page 294. And I just invite the court, it's probably easiest for the court just to read 142, 146. And so after that, to complete the picture, going back to page 306, the judge picks things up from what he takes from the evidence. And I'm sure the court's read this before, but if you just read what the judge says at page paragraph 170 to 173. So, having taken the court through the as it were, the chronology as it develops and ended up with the judge's reasoning, in my submission, it's clear what the judge did. He disregarded the conclusion or the valuations of both experts, and instead valued GBRK on the basis of effectively his own methodology, or a different methodology, which was to prorate Mr. Simmons. And we make two, in my skeleton argument, we make two criticisms. I'm moving now into my submissions effectively on the points for the appeal. We make two linked complaints. One is that there's no, the judge didn't give a good reason for not following Mr. Hall's valuation methodology as at October 2011. And the second is that there was no good reason for departing from that valuation. And so, just on the first limb of those submissions, to summarise the position, the experts agreed that as at 2011, GBRK couldn't be valued on a going concern basis, and as a consequence, they both agreed that GBRK couldn't be worth more than 400,000 by reference to its net assets. The judge's figure based on Mr. Simmons was higher than any of the experts of Mr. Hall, so we saw it going from 660,000 odd down to 400,000. And I say crucially, Mr. Hall considered that Mr. Simmons was an arm's length or commercial investor, but he did not use that implied valuation to change his own net asset valuation as at that date. And I submit that no doubt he had in mind the points in the document I showed you. Instead, what Mr. Hall did was he used it as a commercial cross-check to favour his own net assets valuation over that of Mr. Haywood Crouch. And the short point really is this, is that Mr. Hall is the expert in valuing companies, and the judge failed to explain why Mr. Hall's approach to the valuation was wrong in circumstances where it proceeded on the same factual basis as the judge ultimately found, namely that Mr. Simmons was a commercial investor. My learned friend makes the point in his cursory argument that the judge's decision was consistent with the expert evidence, and he makes the point that has been made to me in the course of these submissions that Mr. Hall didn't suggest it would be wrong to use an equity investment based on Mr. Simmons' investment. In my submission, it's clearly not the case. Mr. Hall didn't. He clearly reached a conclusion as to value, which must have involved a rejection of that methodology, even though he posited it. And moreover, Mr. Hall didn't, in cross-examination, as it were, change his mind and conclude that the company was worth twice what his previous estimate was, based on a methodology that he was aware of from the beginning. And were Mr. Hall seeking to amend his valuation on it in the witness box, he would obviously have said so. Nor in my submission did anyone suggest that Mr. Hall had somehow changed his valuation. We don't need to go to them, but my own friend's closing submissions didn't suggest that Mr. Hall had done that. What he said was that Mr. Hall's view was 400,000, but he invited the court to conclude based on Mr. Simmons that actually the true valuation was higher. Nor in my submission did the judge consider that Mr. Hall had changed his mind, and that's clear from what the judge said at paragraph 163, which we don't need to go back to, but you'll remember I delayed on that because the judge said was the effect of that he would have been prepared to accept Mr. Hall's valuation had he not thought that there was a more better and more reliable valuation available. So in my submission, what the judge did here was effectively conclude that he had a methodology that was superior to that which was actually adopted by the experts. And to that extent, this is a case that's similar to the Smith and Co-op decision that I took at the court at the start of my submissions. And I say, of course, that the judge wasn't here bound by the conclusions that were reached by the experts, but if he wanted to depart from them, he had to have a cogent reason for doing so. In my submission, he didn't give one. The notion that the judge can do better is not, as a matter of law, and without putting the proposition to the witness, a good enough reason to deviate.
Well, yes, I hear your submissions, but to say the last part is putting it a little bit high when one looks at the cross-examination, which is recorded at 167, which is in answer to questions in cross-examination. He said the other guide to its value is the value at which the 20 shares are subscribed to, etc. Because those are market transactions, but I guess we'll come to that at some stage. And he later said the market value, I would suggest, is better informed by the price at which shares were bought around that time. So I'm not saying there's any rejection or acceptance, but there is a discussion of the two possibilities, and that is recorded by the judge in that way. And so it's not quite as stark, I suggest, Mr. Cook, as you just suggested.
Yes, perhaps. I mean, perhaps what I'm relying on really is Mr. Hall's own conclusion as to prefer that method of valuation. And in my submission, what the judge needed to do was to give a cogent reason for departing from that conclusion in going to using Mr. Simmons. I've already made the point. I think that the methodology of valuation is itself a matter which lies within the expertise of a company valuer. So that was a decision that they took. It's not a situation where they lay out the options and they choose one. That choice of itself is a matter of expert evidence in my submission. And clearly, without exploring with Mr. Hall why he didn't use it, the judge is obviously not going to be easily in a position to explain why he should depart from it. I mean, Mr. Hall, in my submission, clearly didn't think that was the best or most appropriate way of valuing the company. So if the judge had been minded to go for a different valuation, it was clearly important that he needed to distinguish himself from Mr. Hall's conclusion that it wasn't. So those in summary are my submissions under the first sort of limb of the argument. The second part is that, and further, and in any event, there was no good reason, in fact, to adopt a valuation based on Mr. Simmons instead of relying on the conclusion of the experts. I make 4 points in this regard. The first is that reliance placed on Mr. Simmons by the judge was inconsistent with the judge's finding that GBRK was both cash flow and balance sheet insolvent in early October 2011. Now, I understand from my learned friend's skeleton argument that he disputes that the judge found that GBRK was balance sheet insolvent. I'll obviously let him make his submissions on that and respond accordingly. But my position is that he clearly did, and it was by reference to Mr. Hayward Crouch's report, which does precisely that, and that's something that Mr. Hayward Crouch, the balance sheet basis of Mr. Hayward Crouch's conclusion was the only type of insolvency that was in fact accepted by Mr. Hall. So, in my submission, it's clear that the balance sheet, at any rate, must have been found. And clearly, of the two types of insolvency here, balance sheet is more important. It's highly unlikely that after a cash injection of 300,000 from the two sets of investors, a company which was previously worth nothing or very little could be worth 800,000. That would be to create about £500,000 in value from nowhere. Furthermore, I say that 3 consequences follow from the judge's finding on insolvency. The first is that if the company was insolvent, it could lawfully trade. So accordingly, the only appropriate valuation methodology was really to adopt a net asset valuation, as both experts did, and rather than adopting a valuation that assumed that GBRK was continued as a going concern. Of course, here the court remembers that the purpose of valuing GBRK was as a proxy to valuing GBR. So, in my submission, the proper methodology, as both experts recognised, was to value GBRK on a breakup basis. The second point I'd make in this regard is that it meant that the relevant counterfactual for assessing equitable compensation, that GBR would have finished trading while insolvent. Now, I recognise, of course, that equitable compensation is to be assessed with the benefit of hindsight. But this hindsight to be applied here is that the opportunity was ultimately going to fail in October 2011. Thirdly, in my submission, the finding of insolvency significantly undermines any methodology which treats Mr. Simmons as if he were representative of the market. No reasonable or prudent investor acting at arm's length buys £200,000 of equity in an insolvent company.
But that was addressed by the experts and in cross-examination, wasn't it?
Well, they discussed. I think Mr. Hall discussed using it as a commercial cross-check. Mr. Hayward Crouch's actual valuation, but I think he was saying, well, why would they have invested if that was the case? But
of course, with benefit of hindsight, we know it was a perfectly good investment. It's all turned out well.
Well, my lord, I suppose that's the point. I'm trying to make a distinction, as it were, between GBRK, which we know did go on, and the exercise in valuation as to GBR, which.
Yes, but there's been agreed. I mean, nobody is challenging the use of GBRK as a proxy for GBR at the relevant date. So, I mean, you can't have it both ways by seeking to undermine that leg of the argument.
I suppose all I'm doing is pointing out that by using it as a proxy, one isn't saying, as it were, that the future.
Well, no, on the contrary, you're taking that on board, I think. I mean, using it as a proxy for what the true value of GBRK was in October 2011.
GBR.
Sorry, beg your pardon.
Yes.
Well, yes, but yes, so what you are using as the proxy is the true value of GBRK at 2011.
Yes.
I suppose that's for better or for worse. That's the methodology that's been adopted. And I'm sorry, I'm still a bit puzzled about whether or not the judge did make a definitive finding of insolvency. I mean, it seems to me it's a bit ambivalent the way he's framed it. I mean, he was, I think, accepting on any view that it was balance sheet insolvent. But I thought he was saying that it wasn't absolutely 100% clear. You could say it was cash flow insolvent, giving the support that was available from Mr. Simmons and indeed his parents. So in practice, that meant that the company was able to go on paying its bills as they fell due, albeit with the benefit of this emergency injection of cash.
Yes, but I think he was placing the insolvency at a slightly earlier stage. I think he was saying that because that was the position that the investors came to the company at.
Okay, but I mean, even so, their intervention saved the company from total insolvency.
Yes.
It meant it could carry on and indeed make the foundations for a subsequent profitable rebound.
Yes, but of course,
why was an outside investor acting commercially not entitled to take a punt on it and say, obviously, this is a very high-risk investment, but I'm prepared to put in £200,000 of my money in return for a 20%, sorry, do I mean 20 or 25% stake in the equity?
Yes, this is part of the problem. Mr. Simmons didn't even know.
Well, I know, in a sense, perhaps I may say so, slightly. No, it's a perfectly fair point, but it doesn't take you all that far. On any view, it was a substantial minority shareholding. It wasn't de minimis. And it would translate into quite a healthy share of the assets if they had any positive value, which ultimately they did.
Yes. I mean, my lord, I suppose what I'd say about that is that the judge's conclusion was that the investments wouldn't have come for GBR at all.
Well, so what?
Well,
I mean, putting it rather bluntly. Because it's not GBR we're valuing. GBRK. No,
I suppose the point I'm making is a very narrow one, which is that if one steps back and looks at what was trying to be achieved here, what one can't ignore the fact that the determination was that it was going to stop trading. And I suppose the only point I'm making is that in those circumstances, I accept you're valuing GBRK, but I'm saying that the methodology, the appropriate methodology, is determined by still by the relevant counterfactual. I understand. My lord may say that actually that any kind of valuation of GBRK means all bets are open, as it were.
Well, all I'm saying reflects the fact that everyone agrees valuation is an imprecise business, even when informed by the views of genuine experts, and there's no dispute as to the expert credentials of the two witnesses.
Yes.
Anyway,
I mean, my lord, I can certainly address you on. I mean, we could go to the passage of the judgment where he talks about insolvency, but the efficient way to do it, I think, is probably to. My learned friend is going to make that point.
Yes.
See how he makes it.
See what he says. Yes.
You'll be probably looking at that passage of the judgment, and I can come back on it in reply. I wanted to move on. The sort of second point I make under this part of the argument is that the judge appears to have ignored or accorded no weight to Mr. Simmons' own evidence about what he considered to be the value of GBRK. I took the course earlier to the excerpts which deal with Mr. Simmons' evidence and set it out sort of in full. And one of the things the court will have seen is that Mr. Simmons told the judge that he didn't consider he considered the company to be insolvent, and it definitely wasn't worth 1 million.
But now you're choosing a different horse. You're wanting to take us to and say the judge was in error in not taking into account what Mr. Simmons said himself, when you're telling us that he is looking at an issue of valuation, so he should be looking through the lens of the experts' reports. But you don't like what the experts' report says, so you're taking us back to what Mr. Simmons says, because you've taken us to passages in the experts' report where Mr. Hall says, yes, I know he said that, but, etc., etc. And the answer is it's 2 times 4. So I think, Mr. Cook, you are riding numerous horses.
Yeah, I suppose what I'm saying is that when the judge was considering the question of the position that GBRK was in at that date, he took on board the fact that Mr. Simmons and Mr. and Mrs. Monks considered that the company was struggling financially. So he as it were, did accept that was the view that was taken by those people at that stage. But then I suppose the point I'm making is that he seems to place little weight on or ignore that when it comes to deciding the question of valuation. And obviously, what the experts had said was that all of this was a matter for the court. And I suppose the point I'm making is that in choosing to go with Mr. Simmons as opposed to the experts, the judge obviously had to consider this
He didn't
evidence
go with
as well.
Mr. Simmons, Mr. Cook. That's a completely erroneous way of putting it, with respect. He didn't go with Mr. Simmons. He used Mr. Simmons' evidence, which included that however much he might have been friendly with Mr. Monk, he wouldn't have given that £200,000 if it was for a 1% chance. He wanted 20%, or as he thought, 20% return on his money.
Yes.
That's where he went wrong in getting 20% of the company as opposed to 25% of the company.
Equity.
But, yes, of the equity. But the judge didn't go with Mr. Simmons. In fact, he said whatever Mr. Simmons says, Mr. Hall, in his report, says, regardless of Mr. Simmons, it's worth 800,000.
Yeah, so is what my lady is saying is that it was irrespective of Mr. Simmons' subjective belief.
Well, what the judge did was say, as a matter of fact, I accept the evidence that having formed a conclusion that this was, if not technically, effectively an arm's length transaction or a commercial transaction, he invested 200,000. That's a matter of fact.
Yes.
Nobody's seeking to say otherwise. But when you say you went with Mr. Simmons, you didn't.
I do apologise, my lady. I think I do need to be more precise. I think what I was saying by that, or trying to indicate, is that the judge adopted an evaluation methodology based on the transaction.
Well, that's different.
Well, I'm so sorry, my lady.
And we've already been through this.
Yeah. I think the point I'm making here is that what Mr. Simmons didn't say was that look, I've done due diligence into this business, and I consider the company to be worth $1 million. In those circumstances, one might have understood why the opinion of a contemporary investor would be a valuable indication of the company. But it's quite clear that from what Mr. Simmons' evidence was, that he didn't approach it on that basis. As my lady's observed, he was primarily concerned, it seems, with the return he was getting on his money, or as it were, immediate return on his money, because he talked about 20%, and there is obviously that disconnect between what he ultimately received in the equity stake. But just drawing out the point about Mr. Simmons' investment being objective evidence as to value, as opposed to his subjective intentions. In my submission, clearly it can't be irrelevant what a party thought a company was worth.
Well, my lady's right. You are riding two horses here. Your whole appeal is based upon the premise that the judge rejected expert opinion. Mr. Simmons was not an expert.
No.
Nobody put him forward as an expert. And actually, one of the basic rules of evidence is that non-experts are not entitled to express opinions. Or if they do express an opinion, that the court is certainly not obliged to take them on board.
No, indeed. But well, I'm not going to. I won't repeat the point.
Well, we see what you say in your skeleton.
Yes. The third point I was going to make was that the proration, or using a pro rata approach to Mr. Simmons' investment, was also inconsistent with the judge's finding that GBR had no other sources of funding. Of course, the judge concluded that Mr. Simmons and Mr. and Mrs. Monks were the only source of funds coming into GBR at that time. And so in my submission, there was simply no purchaser available for all of the shares in GBRK. The judge's leap from his finding that Mr. Simmons' investment was a commercial one to his conclusion that the investment was on commercial terms is in my submission going too far. Yes, Mr. Simmons was a businessman and hoped for a return on his money, but that hope was based on his faith in Mr. Monks as an individual. And I've already made the point that Mr. Simmons didn't attempt any formal or informal valuation of GBRK, but we've covered that. So, as I've said, it is more consistent to conclude that Mr. Simmons' investment reflected his hope value in Mr. Monks rather than GBRK. So just to conclude my submissions then, firstly, I submit it wasn't open to the judge to value GBRK at twice the higher of the two expert valuations. Of course, I accept he wasn't bound by them, but I do say that there needs to be a good reason to deviate from them. And that reason needs to recognise that experts are, by definition, people in the court most qualified to provide valuation. And I do say that the judge fell into the error in the Smith and Co-op case that the judge did there. So I would invite the court to allow the appeal and to substitute in place of the judge's award of equitable compensation of $599,000, $199,315, which reflects a reduction of between $800,000 and the $400,000 Mr. Hall concluded the company was worth as at 2011. May I just behind me. Just to explain, we've got the full the reports in hard copy here.
Very much.
My ladies, my lord.
Can you just hold on for
I
a
beg your
second,
pardon.
please? We're going to take these and thank you. Very much. sentence arises, Launcelot? No.
Those are my submissions.
Thank you very much, Mr. Cook. We'll just rise for a few moments. Mr. Shaw, what we want your assistance on, please, is the following. First of all, any point in the expert reports, the full copies of which we now have, which is relevant to this issue, before us as to whether or not the judge was unreasonable to adopt a different methodology, or which goes to support any reasoning that the judge gave in his judgment as to why he preferred that methodology, and we'd ask you to take us to the relevant parts of the judgment in that respect. Also, any aspects of the transcript of evidence that have not been fully contextualised or referred to, and also the point Mr. Cook makes as to the judge's finding on insolvency. If you can take that as your list of first port of call, and we can see where we go from there.
My lady, I'm grateful for that indication. Yes, I'll deal with those matters in that order. First of all, the experts' report. My learned friend took you to Mr. Hall's initial report. It's perhaps easier to stick with the extract that you've seen. It's that was file 3, tab 10. My learned friend took you to page 145. That's an internal page 106 of 123. So my learned friend showed you the table, which was the estimate of GBRK's FME future maintainable earnings. And then he showed you paragraph 10.7, which is page 150 of your bundle, internal page 111 of 123. You put to my learned friend, I may not have got the question, I'm paraphrasing, but I think essentially my lady's question was, is there anything in the report which indicates a preference for one method of valuation over the 10.7 method, which is the value implied by the equity investment? The answer to that is no. If you go, sorry, I'm jumping around a bit, but if you go back to, you've now perhaps if you take up the full report, if you go back to page, if you go to internal page 102, this is the start of the report. The report obviously covers a number of different matters, such as an analysis of the dividends and so on, which were paid out by GBRK. So section 10 is the relevant section on the valuation of GBRK. You see here Mr. Hall set out a number of possible approaches. He doesn't express a preference for one or the other. And then I've already taken you to this, but page 106, so paragraph 10.5, that's the estimate on a future maintainable earnings basis. And then at paragraph 10.6, just for your note, Mr. Hall identifies another possible basis for valuing GBRK, which was an offer made. I don't rely on that, but I just draw it to your attention to show that what Mr. Hall was doing was putting forward a number of possibilities. And then 10.7 we've just looked at, which is the value implied by the equity transaction. And again, it's not relevant for these purposes, but if you just go on through 10.7, you'll see that Mr. Simmons' investment and the investment made by Mr. Monk's parents, it wasn't the only equity investment. There were further equity investments after October 2011. And so Mr. Hall deals with the value implied by those later investments. So, I mean, in a sense, I'm being asked to prove a negative, but there is no statement in this report which says anything to the effect that the valuation implied by the Simmons investment is to be rejected. And nor is there even anything which says I prefer, if I had to choose, I prefer the future maintainable earnings method.
Well, he says something about his approach taken at 10.2.8, page 103. It's under the circumstances I've taken to valuing the business using an earnings approach and making an estimate of its FME at EBITDA, etc.
My lady, yes. I think, I mean, that is to be. That's under the heading of 10.2, where the judge is talking about you can value on a price earnings basis, an assets based approach, or a discounted future cash flow analysis, and it's in that context that Mr. Hall's expressing the view that he's using future maintainable earnings.
Yes.
But that isn't in my submission that's not a rejection in any way of the alternative, which is to look at the Mr. Simmons investment.
In paragraph 10, point 2.7, we see that there is an expert opinion expressed rejecting one of the possible approaches and gives a reason why.
Yes.
We don't see that under 10.7.
Correct. The again, my lady, what Mr. Hall was dealing with here. So I'm not a valuer, we appreciate, but I mean, in essence, if you ask an expert
yeah,
valuer.
Again, I don't want you to give evidence, Mr. Shaw. I'm just pointing out that we don't see it in 10.7, and in 10.6 there's a caveat as to why Mr. Hall does not regard the offer by the Green Group to be a reliable basis upon which to make the assessment, because of 10.62 he has insufficient disclosure and the offer is made subject to further due diligence which could result in a revision of the offer both upwards and downwards. So what I'm inviting you to do, I think, if I've missed anything in 10.7 which disowns this as a possible method of valuation, I'd be very grateful if you draw it to my attention. I might be looking at it and it being hidden in plain sight, and drawing as a comparison that there are, as it were, caveats made as to other valuation approaches. But sometimes you can be looking at something and not seeing, Mr. Shaw. So if I've missed anything. there anything at the end? Because we didn't have the full. So when we get to the end of 10.7. He doesn't.
My lady, the short answer is no, save to the extent that the court's already noted that Mr. Hall dealt with the investment made by Mr. Monk's parents.
Yeah.
He discounted that. Obviously, he was entitled to. He had to assume facts upon which to express an expert opinion. That there's no issue about that.
No.
But I mean, if my lady's question is there any sort of equivalent caveat or disowning, if that's the way to put it, of the valuation implied by the Simmons investment? The answer is no.
Okay. Thank you.
The next document that you've been supplied with now, the full document, is the joint statement,
Yeah.
the memorandum. Just give me one moment. I'm just trying to find the right place to start. Well, perhaps just to put it in context, if you go to page 2, which is just the summary, the contents page,
Yeah.
you see that section 4, the value of GBRK's business on the various dates.
Yeah.
And so then if we move to paragraph 4, which starts on page 20. At 4.1, you see that Mr. Hall, it's recorded that Mr. Hall estimated the value of GBRK at the 18th of October using the 31st December 2011 as a proxy. You see Mr. Hayward Couch's conclusion that the company was worth 280,000 on that date. 4.2. There's the 660,000. My learned friend explained to you where that figure came from. That was on a future maintainable earnings basis. We can then skip over the valuation at the later dates. I should draw to your attention 4.11 valuation methodology.
Yes.
It's usually appropriate to value an established trading business on a market basis, so on a sort of multiple of earnings basis. But depending on the circumstance, a net assets approach may be more relevant. And then we can skip forward. There were various issues between the parties as to whether one would need to make adjustments for things like directors' remuneration. And then if one comes to, excuse me, paragraph 4.4.2, asset valuation at the 18th of October 2011.
I'm sorry, which
I'm sorry,
subparagraph?
it's subparagraph 4.4, sorry, 4.42, and it's at page 41.
4.42, thank you.
And you see under the heading Mr. Hall's opinion, Mr. Hall is recording what Mr. Hayward Crouch had done, which was arrive at a net assets valuation of 280,000 by taking the December 2011 net assets figure and then making some deductions. And then at 4.43, I'm not going to read it out, but essentially what's going on here is Mr. Hall criticised Mr. Hayward Crouch because what he said in essence is that Mr. Hayward, by valuing GBRK at just 280,000 after the equity investments of about 300,000, it must follow that before those investments were made, the GBRK had net liabilities, and that's you see that probably. I mean that's neatly encapsulated in the final paragraph on page 43. It starts with that also implies. And you see the same point really being made by Mr. Hall below at 4.44. Again, the final paragraph, to Mr. Hall, that again raises the question of why Mr. Monks, as GBRK's sole director, decided it was in the best interest of its existing shareholders the addition of Mr. and Mrs. Monks and Mr. Simmons for GBR to continue trading. And then my learned friend took you to 4.45 this morning. Under Mr. Hall's opinion, Mr. Hall notes that the investments by Mr. and Mrs. Monks and Mr. Simmons implied valuations for the whole of GBRK of 985,000, 800,000 respectively. In Mr. Hall's opinion, the investment with Mr. and Mrs. Monks was not at arm's length, but it appears the investment by Mr. Simmons was. So there's certainly no disowning of Mr. Hall's opinion expressed at 10.7 of his initial report. Mr. Hall is certainly not saying, and the company wasn't worth 800,000. And then if you see, I don't recall my learned friend drew this to your attention, but if you see Mr. Hayward Crouch's opinion, Mr. Hayward Crouch rightly accepted, is a question of fact whether the investments made in GBRK in October 2011 and later were arm's length transactions. And then Mr. Hayward Crouch, in the final paragraph, he does not consider that Mr. Simmons' investment was arm's length, and he's proceeded on that basis. So that was the factual foundation for Mr. Hayward Crouch's discounting of the Simmons investment. And then
and before we go any further, 4.46 in the Mr. Hayward Crouch box, we've got something which I hadn't understood before, particularly from the discussion earlier today. Mr. Hayward Crouch agrees with the principle that a minority shareholder will attract a discount, etc. As such, if Mr. Simmons's investment was considered to be at arm's length, this would imply a market value of greater than 800,000.
So he did apply his mind to the question of if it is an arm's length transaction.
Yes.
I hadn't quite understood that. But that's
yes,
my
and
fault,
so I mean,
Mr.
I
Shaw.
was, my lady, thank you. I was going to draw to your attention the way the issue is framed at 4.46. It's important to understand the comments. The issue to which the two experts were opining was the impact of a minority share acquisition, so the Mr. Simmons investment. And I mean, the court has the point, but generally speaking, not always, but generally speaking, a minority shareholding attracts a discount due to a lack of control. So that would imply the value is greater than 800,000. One might say that was sort of contrary to my case. This is not something I pursued, because that would have opened up a great deal more complication, because the question about the amount, whether a discount is appropriate and the amount, it depends on things like the transferability of the shares, all that sort of thing.
But for me, Mr. Shaw, it was just confirming the issue of whether there was anything about what Ms. Hayward Crouch would say if it were assumed that the investment had been at arm's length, and there is.
Yes. And so it's in that context, I mean, my lady friend's already made submissions to the court on this. What Mr. Hall meant in his opinion, all that Mr. Hall was saying, he was agreeing that if one applied a minority discount,
No, I think you're missing the point, Mr. Shaw. My lady's point was Mr. Hayward Crouch, who refused to undertake that particular exercise, and we understand exactly what you're saying about the minority shareholding point, but Mr. Simmons, and my lady draws your attention to us, as such, if Mr. Simmons' investment was considered to be at arm's length, which the judge did consider it to be, this would imply a market value of greater than 800,000. So
I'm sorry, my fault was not acknowledged. I understood the point. I'm sorry. I should have acknowledged,
yes.
Lady Justice. No, I adopt that. I moved on too quickly to just explain. But no, I understand the point, and respectfully, I adopt it. It was, it wasn't the way my learned friend presented his appeal today. One of the themes appeared to be that actually there was some sort of conflict as between the experts and the Simmons investment, so that the judge got it wrong by basing his valuation on the Simmons investment, or at least he didn't sufficiently explain why he departed from the expert opinion. But as this comment demonstrates, I say there just simply wasn't a conflict at all. I mean, it was accepted by both experts that it was for the court to decide whether it was an arm's length transaction, and so the significance was a matter for the court.
But that's not the point that I was making either. What I'm saying is there was evidence that Mr. Hayward Crouch accepted that if it were decided that this was an arm's length transaction, the effect would be,
yes,
it would imply that the market value was over 800,000. That's all.
Yes. Sorry, just double check. Sorry, just before we leave the memorandum, so you may have picked it up already, but if you just go back up to page 46, Mr. Hayward Crouch's opinion, I don't ask you to read all of it, but if you just note again the final paragraph, he again reiterated it's a matter for the court.
And I just also note in passing that on page 49, under the 4.51 box,
on page 49, it's the end of the first paragraph under Mr. Hall, and it's saying that they're looking at a future date. I appreciate that, but they're looking at Mr. Simmons's investment and his share dividend, and at the end it says, albeit with hindsight, the price at which he acquired his shares in GBRK was a reasonable commercial decision.
I'm grateful. And the final document that you've been handed is Mr. Hall's supplemental report, which was filed a day after the.
We haven't been handed that report. I think we've already got it because it's only a short one. It's in the.
Oh well, I didn't have the full report in my bundle, but as long as everybody does.
We don't.
didn't
We've
have it
only been
before,
handed
but it's a pretty
those.
lot. We've got most of it, I think, one way or another.
Those two. Is there something that's not contained in the bundle?
While the court rose, my learned friends gave me the full, the initial report, the supplementary report, and the joint statement.
We've only had the initial report and the joint statement.
I'm so sorry. We meant to hand up everything. It's a much shorter stapled document of 65
Thank you very
pages.
much.
I've got 2 copies here.
There's a third one there. So, Mr. Shaw, looking at the time, is there just one more point on the documents, and then we'd move on to the next topic?
Yes, absolutely.
Yes.
Yes, of course.
So let's deal with that, and then we'll rise for the short adjournment. Thank you very much. We now are about to have it.
Thank you.
Just to put this in context for the court, you have the dates in mind. The joint memorandum was the 31st of March, 2021, and then each of the experts had a right of reply, I suppose, and this is what you have here. You have Mr. Hall's reply.
Yeah.
If you just see the way, if one looks at the introduction, page 4 of 65.
Yeah.
All that Mr. Hall was doing here was revising his calculations of the value of GBRK based on future maintainable earnings. So there's no need. I don't think there's a need to go into the detail. But if you flick, essentially what Mr. Hall did was look for comparables, and if you just flick through the report, you can see what he's done is taken real transactions, such as page 11 of 65. He identified that Skipaway Waste was a target company, and he's done some analysis to work out the relevant multiplier for a number of transactions, and that's what the whole report is. If you just flick through, it's a series of it's an analysis of a series of transactions which Mr. Hall then used for the purposes of valuing GBRK.
Well, what we know from the introduction of the joint memorandum is that this was a joint statement prepared in accordance with the rules, and where, as it says, 1.5, there is a difference. The experts' adoption of their respective instructions differ, as do the respective approaches taken in each expert's reports. Consequently, in section 2 of the statement, a summary of the respective instructions and approaches is set out. Thereafter, the statement is presented in the order of the matter to be addressed, as set out in each of the court order. And it makes it quite clear that if it's felt by Mr. Hayward Crouch that there's been no address of a certain issue, then there'll be a short supplemental report.
Exactly, and again, it's a question of demonstrating a negative, but all that Mr. Hall was doing was revising his calculations of future maintainable earnings. There is nothing in here about the valuation implied by Mr. Simmons' equity investment.
No, because it all depended on the finding of fact.
Correct.
Yeah.
So
your point is that it didn't need to be included.
Exactly. There's nothing. I mean, to pick up my lady's point, there's nothing certainly expressly, nor is there anything, nor is there any implication that Mr. Hall was abandoning his position in relation to the 800,000.
No.
Unless I can assist the court further on the documents.
Now, obviously, if you see anything over lunch, we're not going to stop you drawing it to our attention. But I'm sure, Mr. Shaw, that you and Mr. Cook would have had this very much in mind several times as you prepared for the quantum trial. But thank you. May we resume at 2? It's 55 minutes, but thank you.